Hello, I'm Rex Hogue, and I'm here to talk about the single trust for this session. And I want to start by just showing you that the binder, what I'm going to be talking about is behind the tab labeled Living Trust Agreement. Now, the trust itself is broken down into several articles. Each one is individually paginated. So I'm going to walk you through what's behind each article. I'll talk about some of them a little more than others. First article is establishing the trust. For a single person, that's basically either establishing the trust originally or the restatement of the trust. And it basically says that you as the trust maker are the beneficiary as long as you're alive, and the instructions in the trust as long as you're alive pertain to taking care of you primarily and perhaps minor children. Another thing that's in Article 1 is the homestead provision. Now, your trust, if we drafted it, is a qualifying trust under the Texas Tax Code and the Texas Property Code, and that means that your trust can go that means that your trust can hold your homestead, and you still get all the homestead advantages. You get the ad valorem tax exemption. If you're over 65, you get the freezing of the tax. You get the asset protection from bankruptcy. And you continue to file your tax returns on your 1040. Article 2 talks about family information. Typically, it's going to name who your children are and perhaps, hopefully not, but deceased children if you've elected to name them. And it may also indicate, if you have decided to leave someone out, the first place in your document where you intend to do that might be in Article 2. Article 3 is called Trustee Succession Provisions. There's really only two things we generally look at in here. One is who the successor trustees are on death and incapacity. Now, we gave you a sheet, we emailed it to you in most cases, called the estate plan summary information. And in there it names your trustees. We do want you to review these in your trust to make sure that the names are spelled correctly. The input for the trust and the other documents is done separately. Sometimes we do make mistakes. Sometimes people don't really notice the mistakes in the email we sent until they see it in writing in the trust document. And for some reason they catch it more in the trust than they do the summary. I don't know why. Another thing that will be in Article 3 that we do go over if you have the Heritage Trust is how the beneficiaries control their share. If you don't have the Heritage Trust, that particular section will not be in there. The next article is Article 4, and it covers the trust protector if you had a trust protector. Now, the purpose of the trust protector, as the name implies, is to protect the trust from things that we cannot predict at the time you do your planning. The powers that the trust protector has are very broad, but there is a reason that all of them are in there. And when you read through it, don't panic about anything. We can change anything in here. However, before you change it, you need to understand why it's there. That's the most important thing for you to know about that particular section. If you don't have a trust protector, then Article 4 is going to be administration of my trust during my incapacity. We typically do not go over this article with clients. We do have you read it at home. It contains a number of instructions. Now, I hate to call them generic because they're really not. They're things that we've developed over time to take care of clients in particular situations. We have found that these instructions are fairly universal, i.e. they are going to work for 97 or 98% of our clients. But we do encourage you to read it, and if there is something that you either want to change, delete, or add, let us know. The next article will either be Article 5 or 6. It's called the administration of my trust upon my death. This is the first, what I call boilerplate article in your trust. And when I use the phrase boilerplate, what I mean is all of our single clients get the exact same article here. It doesn't vary from one single client to the next. And we don't go over that with clients. I do encourage you to read it just so you'll understand what happens. The next article is the disposition of tangible personal property. This is either going to be Article 6 or 7. Now, if you made specific distributions of tangible personal property, or in some cases, specific assets, those may be listed in this particular article. The other thing that's in this article is a way to resolve disputes between beneficiaries. Now, sometimes people think, well, I only have one child. Why would I be worried about a dispute? Well, unfortunately, none of us know the future. That one child you have may have multiple children. If your child predeceases you, you may suddenly find that the people who would inherit might be multiple people, and we don't want them to get lawyers and sue each other over the distribution of assets. So that article sets up a lot of rules about how to resolve those disputes. Another thing that we've started putting in there is how to distribute firearms. Firearms are very tricky, and we now have rules in place to help distribute firearms so that you don't turn the people you love the most into felons because of improper firearms transfers. The next article, if you have charitable shares, well, I'm sorry, I'm one article ahead. The next one is creation of shares upon my death. Now, that article really doesn't say a lot except to put in instructions to divide the shares according to future articles. The next possible article might be creation of charitable shares, and that might be Article 7 or 8. Could be as late as Article 9, I suppose, but that simply says this is how I'm going to divide the charitable shares, and then the next article provides the instructions for how it's to be distributed to each share. And we would have gone over this with you in the design interview, so this is something that we typically review with you when we do these reviews in person. Look over that section carefully, make sure that we've got the right charity named, that we've got the right provisions, and that we did it the way you wanted to do it. If you don't have charitable shares, the next one is going to be distribution to beneficiaries, and that could be anywhere from Article 8 to 10. Now, if it's distribution to beneficiaries, that means that you don't have a heritage trust, and there's just basically one layer distributing, and there should be a little chart in there unless you have only one child or one beneficiary, telling you who the beneficiaries are, their relationship to you, and what percentage they get or what fraction they get. We can't always use percentages. If you did a heritage trust, then instead of that article, you're going to have two articles. One is called My Exempt Property, and the second one is called My Non-Exempt Property. You will see a chart in both of those, like the one that would otherwise be in the distribution to beneficiaries. It's going to say who the beneficiaries are, their relationship to you, and how much they get. And then it's going to outline how those shares are distributed to them, or more importantly, how they're managed, since in a heritage trust we don't truly do distributions. I'll explain that more in the section on heritage trusts. The next article, and it could be anywhere from Article 10 to 13, is remote contingent distribution. Now, we rarely ask clients about that, and here's the reason why. We typically assume that upon your death, if all the people you want to see benefit have predeceased you or die at the same time, that it would just go to your more extended family, or by what is called intestate succession. That's the default that we put in. if you want someone specific, maybe you don't want it to go to your Uncle Joe because he's weird or something like that, and you want to specifically leave it to Aunt Susie instead. You can do that there, or virtually anything else you want to do, you can leave it to a charity, but if you don't bring that issue up, we don't plan for it. However, we are happy to make those changes at no cost to you. That is not a design change. The next article is distributions to underage and incapacitated beneficiaries. Now, I'm going to say that this is normally a boilerplate article. There is one exception. In some cases, we have provisions for beneficiaries who might go to college. But this section talks about the special rules that apply if you either have an underage beneficiary, typically defined by your trust as under the age of 25, or incapacitated beneficiaries. This article does not apply to a great number of clients, but it's like the sweater in the suitcase. If you ultimately need this, somebody will be glad that it was there. The next three articles are true boilerplate articles, meaning they don't vary. The first one, and it'll be Article 12, 13, 14, or 15, is retirement plans and life insurance policies. It's just for the administration of those types of assets. Then Article either 13, 14, 15, or 16 is called trust administration. It talks about the basic rules of administering your trust. A lot of these provisions are in the Texas Trust Code, but we've added enhancements, and some of it's based on case law. The next article, going to be Article 15, 16, 14, 15, 16, or 17, is called My Trustee's Powers. That sets forth the authority that the trustee has on everything from banking to settlement powers. They're generally in alphabetical order. Again, some of this comes from the Texas Trust Code, some of this comes from the Property Code, and we've added enhancements in here that have been helpful to our clients down through the years. The last article is called General Provisions. I refer to this as the kitchen sink provisions. Now, it's not exactly a boilerplate article, but for the most part, there's not any real variables here. There are a couple. One has to do with whether you're doing the Heritage Trust or not, and that's really the main one. Now, there might be some definitions that'll be particular to you, though most of the time definitions are pretty universal. In my 27 years of practice, I've only had two people change a definition, and that may sound silly, but it made perfect sense in both of those cases, but we don't spend time going over that article. Before you get to the definitions, there is a section that talks about challenges, no challenge clause. That's known as an interim clause. That clause is very long, it's very detailed, because in order for them to be valid under Texas law, they have to be very specific. Another thing that's in there, it talks about terms like him and her and they, singular and plural terms. Those terms are not substantive, they're there for convenience, and if it says him and it should say hers, that doesn't do any harm to your trust. We would love to get that right, but sometimes someone is serving and maybe they're a different sex than we anticipated, who knows. Then one of the last subsections in there is a section that says if one part of this trust were deemed to be invalid, it doesn't invalidate the entire trust, it just invalidates that one section. After that comes your signature and the signature of any other trustees who may be serving, and typically on the next page is the notary's signature. That's a quick review of your trust. Do take time to review it. Remember, you have 90 days to review it, and make changes at no cost as long as they're not design changes. Thank you.